The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 973, and it is coming to you on Monday, the 18th of May, 2020. We are now in the 24th year of The Law and You. On this program, I will speak to you on the topic, gifts of property. But as usual, before getting into the program, a few preliminary remarks. Firstly, I would like to send out my condolences to all families which have suffered recent bereavements. And secondly, on a happy note, let me say belated happy birthday to Sir James' son Mitchell, who celebrated his 89th birthday last Friday, 15th May. I know you had a happy birthday, Sir James. I had the pleasure of speaking with you. I called you to wish you happy birthday because you have fulfilled a very important role in the history of this country. And for that, we must express our collective appreciation to you. I hope you will live to see many more, but I know in the Mitchell family, you live very, very long. All the very best, Sir James. All right. Gifts of property. As viewers of the program would recall, I have done several programs in the past dealing with deeds of gift, so that some of what you hear me say tonight may be a repeat of what you have heard before and already know. But there are always new viewers, young people who hitherto did not take the program seriously and are now into their maturity, and they pay more attention to legal matters. So there are always new people. That is why I frequently repeat items of law which I have dealt with before, for the benefit mainly of those who are new to the program. This is a very important topic, as you will see. Very often, an elderly person promises to leave a piece of land or a property to somebody. Might be one of their children, might be a close relative, or it might be a very faithful caretaker. You know, somebody has looked after the elderly person for a long time, is very faithful, does it sacrificially, is paid very little for it, and the elderly person, who all he or she might have would be a piece of small parcel of land or a small house on a piece of land, and decides, look, I'm going to leave this property to you when I die. I want you to have it. Well, as you all should know by now, if all that elderly person does is to say that he or she is going to leave a piece of land or property to somebody and then dies, those words mean nothing in the eyes of the law, because the law requires promises dealing with real property to be either in writing or what is called evidenced in writing. Now, I would therefore advise you strongly that if you intend to leave land or property to anybody, you should either make a will or, better still, give them a deed of gift while you are still alive. Therefore, the first thing you should do if you decide to leave property to anybody, or if anybody has promised to leave property for you, first thing you should do is to consult a lawyer. Make an appointment, go and see a lawyer. And in these COVID-ridden days, if you go to a lawyer, make sure you are wearing your face mask, because most lawyers' offices now have adopted defensive postures following the advice given by the Ministry of Health and the officials that persons should have their face masks and you should sanitize, so that when you go to most lawyers' offices these days, you will find that you're required to, sanitize your hands and certainly to have on your face mask. And that's just by the way. So, you make an appointment, go and see a lawyer and say to the lawyer, I am interested in giving this piece of property, this piece of land or this property to so-and-so, and I would like some advice as to how to go about it. Well, the lawyer is likely to advise you that there are one of two ways you can go about it. Either by making a will and leaving the property to the person in the will, or by doing a deed of gift to give them the property right away. Now, one of the first responsibilities that the lawyer will undertake will be to make sure that the land or property which you intend to give to somebody is yours to give. Because, as you know, you can't give away what is not yours. Or if all you have in a parcel of land is a share, and other persons own the other shares in that parcel of land, you alone can't give it to anybody. It could only be given away if everybody who has a share agreed to give it away and sign the deed to convey it to the person to whom the property is intended to be given. Therefore, the lawyer's first responsibility is to make sure you have what is called title to the land. Clear title. That is not mixed up with any other person and not subject to any controversy as to ownership. You can't say, well, I have this lot of land because I got it from my father and he died long ago. And the lawyer will ask, well, did your father give you a deed or did he leave a will? And you say, no, but he just gave it to me, and since he died, I've been occupying that parcel of land. And then the lawyer might ask, well, did your father have any other children? Yeah, it was 4, but he decided to give me because the others wasn't studying. Well, the lawyer will say that we have to take steps to make sure you have a proper title to that parcel of land. Otherwise, you can't give it to anybody. You can't sell it. You can't go to a bank and borrow money or to a credit union and borrow money on the security of that parcel of land. Excuse me. Therefore, in a nutshell, the lawyer will make inquiries about your right to the land. Perchance you have a deed for the parcel of land you want to give away. That is the best. If you have a deed, the lawyer will then send his or her clerk to the courthouse to investigate the deed. In other words, to make sure the deed is still a good deed, to make sure it is valid, to make sure there are no encumbrances on it. Occasionally, an elderly person becomes forgetful and might not remember that, yes, they have a deed for a parcel of land, but 20, 25, 30 years ago, they had allowed one of their children to use the deed as security for a loan from a lending institution. And that they hadn't remembered that that occurred. Now, at the courthouse, that mortgage deed which encumbered the old person's deed is registered at the courthouse. And therefore, if a search is carried out, the searcher will see that in 19 so-and-so and the early 2000, you had used that deed to lend somebody to take out a loan, to mortgage. You had used your deed as security. And it had not been released from the lending institution. So the lawyer will make steps. Assuming the loan was repaid, the lawyer will take appropriate steps to have your deed released. So then your deed becomes free. And if the searches reveal that you did nothing more to encumber your deed, you didn't sell the land, you didn't give it to anybody beforehand and forgot that you had done so and so on. If the title is clear and the title deed is good, the lawyer will say, okay, we're good to go. And then the lawyer will advise one of two courses of action, either a deed of gift or a will, and the parties will decide which one they prefer. Generally, the better option is to have a deed of gift done right away. Because if you just make a will, leaving it to whoever you want to leave it to, there might be problems. So, once it is ascertained that you have the right to give away this parcel of land, the better option when you decide to give it to somebody is to have a deed of gift done. If it is a dwelling house in which you live, I am always advising you that when you sign a deed of gift, or before you sign a deed of gift, you tell the lawyer you want your lifetime in the property. Because if you are going to give away property to somebody, even to one of your children, and you live in the property, you want to make sure that you would be allowed to live in the property till your eyes close. So the deed of gift should have a clause saying that you have kept your life interest in the property and you give it away to somebody subject right to your life interest. In other words, they get it when you die. Now, once that deed of gift is registered at the registry, whereby you have given it to somebody, it is extremely difficult for you to take it back against the will of the person to whom you have given it. If there's a controversy and people quarrel and so on, and the person gets fed up and say, look, I don't want it. I don't want to get involved in all this controversy or the children cussing me and so on and so on. I'm giving it back to you. Then the person to whom you gave it could always go and sign another deed of gift, giving it back to you. Of course, you would have to pay money in the form of stamp duty, but that is something else. But if later on you change your mind, having given property by deed of gift to somebody and that deed is registered, if later on you change your mind and you want it back, sorry. There are few circumstances in which the law would allow you to get it back if the person says, I'm not giving it back. I'm not signing anything. Perhaps one of these days I'll do a program on the possibility of getting back property you have given by deed of gift, but it is extremely difficult. And if the person to whom you have given the property has gone and mortgaged the property with a lending institution, it would be almost impossible for you to take it back if it is subject to a mortgage. Excuse me. Therefore, if an elderly person forms the intention to give property, real property, either a piece of land or land with a building, to you, and you have gone to a lawyer to fix up the papers, among other things, the lawyer will want to make sure that the elderly person who is giving that property to you is in her or his right mind. How would the lawyer know if the elderly person is in his or her right mind? Well, the lawyer would speak with the person and try to form an impression as to whether that elderly person really knows what he or she is doing. And the lawyer would explain to the elderly person what is involved. The lawyer will say to the elderly person, listen, if you sign a deed giving this property even to one of your children, you can't get it back. And the lawyer would generally satisfy himself or herself that the elderly person understands what is happening. But if the lawyer has any reason to doubt whether the elderly person who is giving this property away is in his or her right mind, the lawyer is likely to advise that the person should be medically examined so that the lawyer makes an arrangement to the person to go and see somebody at a psychiatrist, a mental hospital, a doctor who is qualified to pronounce on these matters, and that doctor will examine the person and would be able to sign a paper to say, yes, this person is his or her right mind, or no, this person does not understand what he or she is doing. This person is not mentally competent. Now, it doesn't matter if the elderly person is literate or not, because you might not be able to read or write, but you may have some common sense and know what you are doing. And if you cannot read and write and you want to sign a deed, the law provides a procedure by which somebody who is called an official attestor can make your mark for you and sign a declaration to say, this person cannot read or write, but this document was read over to the person and the person thoroughly seemed to understand the same. And he or she made his or her mark in my presence, and I countersigned it. Usually it has to be a notary public or somebody at the registry or somebody in authority. The law has a list of persons who are qualified to witness the signatures of persons who cannot read or write. So that some person can read and write, but they might not be in the right mind. They may have a problem with their discernment. Their brains may not be wholesome. And one of the problems that the elderly suffer would be problems of perception, problems of the brain. They can read, they can write, but they cannot think properly. And various brain problems which their doctors trained to analyze and to pronounce upon. Therefore, a lawyer who is asked to prepare a document to transfer land from an elderly person to another person covers all these bases. Because if it turns out that the person had a mental problem and the lawyer did not take steps to ascertain that the person was in his or her right mind, then there could be problems with the lawyer later on if there is a controversy about the soundness of the deed. But the fundamental problem which that lawyer who you go to will have is to make sure your title to the property is good. Either that you have a title deed for the property or you are in a position to get a title deed. Now that is a different story, and we've talked about ways in which you can get a title deed to property if you don't have one. Either by applying for letters of administration to the estate of the person to whom the property used to belong, if somebody that you descended from, and you're one of the beneficiaries, and the other beneficiaries sign to agree that you will get the property and so forth. Or by taking out a possessory title to the land. An elderly person may say, look, I have had this land in my possession for 20-something years. Well, the law just requires 12 years or more, but in most cases, the person can say, look, I have had this land for 25, 30 years, 40 years. I have worked this piece of land. I've lived on it, or I've been near to it, and nobody else could challenge me, and so on. Then the lawyer would advise, okay, we have to take out a possessory title using the procedure set out in the Possessory Titles Act 2004. And in due course, we might be able to get the judge to pronounce that yes, this person has satisfied the court that he or she has good title to this land by virtue of 12 years and more of adverse possession. But what you have to remember is that you cannot give away property if you don't have some title to the property. You cannot just say, oh, it belongs to me, and I'm signing it over to so-and-so. The law requires you to prove that it belongs to you before what you sign could be regarded as valid and effective. Okay? So the bottom line is, go to a lawyer when you have these things. And don't wait and say, well, look, one of these days we'll go to a lawyer. One of these days. Well, before one of these days passes, the person who intends to get the property could die and pass away. And therefore, once the intention is formed, act on it right away. Don't wait. Go and get up and get. You know how many people say, oh Lord, did they plan to give me, but he tell me you want to give me. Well, that is of no use when the person has died. So did say and did tell me and did intend forgive me and so on. Those things mean nothing after death. And we all know death is uncertain. So the moral of the story, get up and get. Okay? All right, that's all from this program of the Law New program number 973. I look forward to being of further service to you next week, Monday DV, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls. Take care of yourself. You all know what you are supposed to do and not do. And may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.